Voluntary liquidation of the company. Once we file an application for voluntary liquidation, there is no specific provision for withdrawal under IBC. Today we are discussing very important development under Insolvency and Bankruptcy Code 2016, whether the NCLT can permit withdrawal of voluntary liquidation, even though there is no specific provision in the IBC for such withdrawal. We'll explore the recent ruling by the Honorable NCLT Chandigarh and understand its legal implications and rationale and impact on stakeholders involved in voluntary liquidation proceedings. We'll see the background of the case. Under Section 59 of IBC, a corporate person who has no debts or has paid off all its debts can initiate voluntary liquidation. Once this process is initiated and admitted, it is generally treated as irreversible unless provided otherwise. But what happens if the company that has entered voluntary liquidation decides to withdraw the process in the midway? There is no express provision under Section 59 or the related guideline regulations to allow such withdrawal. This is exactly what came up before NCLT Chandigarh Bench. The ruling by NCLT Chandigarh, the company in question had initiated voluntary liquidation proceedings under Section 59 of IBC. Later it realized there was a viable business opportunity or reason to continue operations and start to withdraw the liquidation. Then the adjudicating authority noted that the IBC does not contain a specific provision for withdrawal of voluntary liquidation once initiated. However, the NCLT has inherent powers under Rule 11 of the NCLT Rules, which allows it to make such orders as may be necessary for meeting the ends of justice. So the tribunal observed that since no creditors were affected and there was no public interest involved, withdrawal would not prejudice any stakeholder. Thus, invoking Rule 11, the NCLT permitted withdrawal of the voluntary liquidation process. You will see Rule 11 of NCLT Rules 2016. Nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for ends of the justice. This is what Rule 11 of NCLT Rules 2016. So this provision is similar in nature to Section 151 of the CPC, Civil Procedure Code, granting courts or tribunals the power to act in the interest of justice, even in the absence of specific statutory provision. So the decision of the NCLT Chandigarh is significant because it sets a precedent that voluntary liquidation is not irrevocable if compelling circumstances justify withdrawal. It recognizes commercial flexibility for solvent companies seeking to revive. It provides an avenue for entities to withdraw even in the absence of an explicit enabling clause in the IBC. However, this cannot be misused. The tribunal has clarified that such withdrawal may be permitted only when no stakeholder is prejudiced, no fraudulent intent exists, and the application is made in a good faith. If you found this video helpful, please do subscribe. We have 2 channels, RR Corporates and RR Legal Talks. Hit the bell icon so that you will not miss any of the latest updates. Thank you.